Hey everyone, welcome back to Guns and Gadgets, your premier source for Second Amendment news that matters most to freedom-loving Americans. If it affects your right to keep and bear arms, you'll hear it here. So, take the opportunity now to hit that subscribe button down below. It's free, doesn't cost you anything, it just keeps you in the loop and makes you a member of this growing freedom family. It helps the channel out drastically here on YouTube, so I humbly ask for you to consider hitting that subscribe button because like 40% of the viewers don't subscribe. So help the channel out as I bring you the news every day. Now buckle up, folks, because today we're diving into a case out of the First Circuit Court of Appeals that could have huge implications for the Second Amendment, and it's one that bears watching by all. We're talking about mandatory waiting periods for firearm purchases. And the big question the court is wrestling with is this. Is it constitutional to force law-abiding citizens to wait before they can take home a gun they've already legally purchased? Well, we all know the answer to that, but before we continue, I want to thank our friends over at Blackout Coffee Company, patriotic, family-owned, and unapologetically pro-Second Amendment. If you want to fuel your fight for freedom while sipping on some of the best coffee America has to offer, head over to blackoutcoffee.com/GNG and use code GNG10 to save 10% with your order. All right, whether you're gearing up for a day at the range, we have our premium instant coffee. You can just throw it in your backpack. Or if you're watching corrupt politicians squirm in court, do it with a cup of Blackout coffee in hand. Appreciate your support. All right, let's break this down. We're looking at this case. It's involving Maine, the state of Maine's law, which requires a person to wait 72 hours before they can take possession of the gun that they legally purchase. Now, the Maine legislature adopted the 72-hour delay back in April of 2024 in hopes that it would reduce the state's suicide rate based on studies showing that states with a waiting period had 51% fewer suicides and that 70% of suicide survivors attempted suicide within an hour of first thinking about it. Now, this is a very touchy subject, and I always question these studies saying, you know, a delay stops something. Now, in my career, I've been on many investigations or scenes or even incidents where this has occurred, and I can tell you that, you know, delays aren't really, I don't know. I always question these studies. You know, it's always a study that's canted in taking away a right from somebody. Now, of the 178 firearm deaths in Maine in 2021, 158 were suicides. Now, let's do this the right way. If you take away suicides, then Maine doesn't have a gun violence issue. They don't have a homicide issue. One study that they quote estimated the 72-hour waiting period could prevent 12 suicides annually. Again, how do you extrapolate that? I don't understand it. It's like crazy science that's way beyond me, but you know, what about delaying other things? Like, do they delay purchases of cordage and rope? Do they delay purchases of pills? Are they going to delay purchases of cars? Because these are ways that people commit suicide as well. Or are they just slanted towards taking away firearms and the Second Amendment? Just keep that in mind. Now, the waiting period runs alongside background checks, and it includes exceptions for, of course, law enforcement, security personnel, gun dealers, certain private sales, such as transactions between family members and antiques. So not everybody has to wait, just, you know, you law-abiding Joe Schmoes. Waiting periods ranging from 3 to 14 days have been adopted in 9 other states. From my quick research, I might be off by a day or two on some of them. And you can add in the District of Columbia in there as well. Those states are California, Colorado, Florida, Hawaii, Illinois, New Mexico, Rhode Island, Vermont, and Washington. In addition, Maryland, Minnesota, and New Jersey impose waiting periods specifically for handguns. Now, if I missed your state or your waiting period, put it in the comments down below, because I try to stay accurate with all this stuff, and sometimes these are difficult to find on a short order. Now, a lower court issued a preliminary injunction against the law, finding that it likely violated the Second Amendment. Likely. Like, really? On appeal, Maine argued that the amendment protects the right to keep and bear arms, but doesn't address purchasing them. Well, okay. So then that means you're going to back up off of everybody who makes their own gun now? See, we can use your BS against you, Maine. But here's the twist, guys and gals. The First Circuit Court is struggling with how to handle this under the Supreme Court's Bruin decision. If you remember, and I'll refresh your memory, New York State Rifle and Pistol Association versus Bruin reset the entire legal framework for evaluating gun laws. Under Bruin, courts just can't say, oh, this seems like a reasonable restriction. No. They must look at the text of the Second Amendment and our historical tradition on firearm regulation. If a modern-day gun law isn't consistent with regulations that existed at the founding of our country, it is unconstitutional, period. And that's what's making these judges squirm. So the question is, does this kind of waiting period have any kind of historical analog in 1791 when the Second Amendment was adopted, ratified, or 1868? Spoiler alert, it doesn't. There isn't a single law from the founding era that required people to wait a certain number of days before buying a firearm. Now here's where things get slippery in this. Maine's Chief Deputy Attorney General, his name's Christopher Taub, argued during this oral argument here that the Second Amendment is implicated only if a limit on purchasing guns meaningfully impairs the right to keep and bear them, such as if there were a 25-year waiting period. This dude's a freaking idiot. And the judges, I guess they should have laughed him right out of court, but that logic goes completely against what the Supreme Court laid down in Bruin. The standard is simple. If the founders didn't do it, the government can't do it now. It's tough for people to figure out and understand. Now, if we said, you know what, you can't talk for 25 years and that doesn't implicate the First Amendment. You can't say anything. You can't talk against your government. You don't have the freedom to assemble for 25 years. You don't even have the freedom to assemble this week. If we did that, people would lose their mind and would say it was a civil rights violation. But for the Second Amendment, that's okay because you're scared. Now, in fact, the U.S. Circuit Judge Laura Montecalvo replied to that, quote, "Your argument is the waiting period is checking on whether people are law-abiding, and I don't see that." And that's pretty good coming from the judge. Which leads to the obvious question here. Why are we even entertaining these restrictions at all if they clearly fail Bruin's test? They're obviously unconstitutional. Make no mistake, this case could impact millions of Americans. If the First Circuit rules in favor of Maine, it opens the door for other blue states to slap on more waiting periods, licensing schemes, and other bureaucratic roadblocks that delay our right to defend ourselves and our family. But if the court rules the right way and sticks to Bruin, it could be another nail in the coffin for gun control laws that punish the law-abiding while doing nothing to stop criminals. This isn't just about Maine. This is about you, wherever you live. If you have to wait weeks or months just to take possession of a legally purchased tool, a firearm, that's not just inconvenient. That's unconstitutional, and it puts you at risk. So what happens next? What happens next? First, more coffee so that I can speak freely. But this First Circuit has to issue a ruling, and we'll be watching it closely. There's no timetable, so we don't know when it'll drop, so stay tuned to the channel. Hit that subscribe button to stay in the loop. If they follow the Bruin standard, they'll have to strike down Maine's waiting period, and if not, we'll likely see an appeal, possibly a future Supreme Court showdown. And to be clear, the Second Amendment doesn't come with a clause that says after a short delay. You either have the right to keep and bear arms or you don't. A right delayed is a right denied. And if the courts are honest, they'll rule in favor of liberty. I'll keep you updated right here as this develops. If you found this video helpful, please give it a thumbs up and share it with your friends. Share it on messaging boards that you're a member of. Make sure that you're subscribed to the channel with notifications turned on so that you don't miss any of the critical updates that affect our rights. And don't forget, freedom is not free. Stay alert, stay informed, and as always, be safe, stay vigilant, and carry a gun. I'll see you on the next one, y'all. Take care.